Welcome, Facebook Live Friday with Joe Novavica from Pardalis and Novavica. The topic today is, who owns my tattoos, really? Sounds like a simple question with an easy answer. Nah. And that's why we're going to talk about a really important case dealing with copyright law and entertainment law. That is, when you're representing celebrity clients who are inked. Who's not interested in tattoos? Today, at least 1/5 of adults in the United States has at least one tattoo. They're personal and sometimes they're intimate expressions of the people who have them. It is who they are, or part of them anyway. The case I think you'll find interesting today is called Solid Oak Sketches versus 2K Games, Inc. Solid Oak Sketches is a company that was formed by tattoo artists. The company, Solid Oak, became the owner of the artist's intellectual property rights. Any rights that the tattoo artist had, they transferred over to Solid Oak Sketches. The artist just so happened to have been commissioned by the NBA's LeBron James, Eric Bledsoe, and Kenyon Martin, very famous ball players. Now, Solid Oaks sued 2K Games. 2K Games had acquired the rights to use the images of those players to create their NBA 2K video games. So the tat artists see their clients on the NBA video game. They also see what appears to be the tattoos that they inked. The tat artists contact the video game company and say, hey, you're showing our tats and we want our residuals. The video company says, no way. The players sold us the rights to use their images, and those tats are part of their images. So that's how we end up in court for 4 years with this case. The closest thing that we've ever seen before like this was involving the Hangover 2 movie, where actor Ed Helms had the tattoo of Mike Tyson on his eye. That case is not helpful to us because they settled it so that they can go forward with the movie. So that case, it came up, but it was never really resolved. LeBron James says, in the last 15 years, I've been playing professional basketball. This case is the first time that anyone has suggested to me that I can't license my likeness without getting the permission of the tattooist to ink my tattoos. No tattooist has ever told me I needed their permission to be shown with my tattoos, even when it was clear I was a public basketball player. Take-Two, the software company, argued that awarding the artist compensation would lead to a shakedown whenever the players appeared on television. LeBron James noted that, his tattoos are part of his persona and identity. He also said that if I'm not showing my tattoos, it wouldn't really be a depiction of me. These are the questions that the court here in the Southern District of New York in Manhattan had to deal with. Is a tattoo something that deserves copyright protection? So we look at, what are the elements? What makes something protectable? Well, we look at the tattoo. Is it something that's original? Is it creative? And I think that's pretty easy. The answer to that is yes. But is it attached to a tangible medium for expression? I mean, what's a tangible medium? You're talking about a canvas. It could be a wall. It could be the side of a truck. It could be paper. But is skin something that we want to have designated by the court as a tangible medium for expression? Let's talk about what the court did do in this case. The court took a look at all of the appearances in the game and listened to expert testimony and noted that the tattoos were visible only for a really short amount of time. The court said, you know what, this use is de minimis, meaning it's so small that it's inconsequential. So that's the main holding of the case. But the court also had problems with the fact that the skin would be considered something that could be protected, or whether an artist would have any ownership rights at all. So the bottom line and the end story of this is that the The artists were not successful and they were not going to get any residuals. For now, anyway, tattoos they belong to the person who commissioned them to be done and who have to live with them every single day. So, what does this mean to attorneys and people that represent celebrities? To avoid a lawsuit, what you're going to have to do is, unfortunately, is have your representative get you a release from the tattoo artist. Unfortunately, that's what you're going to have to do until the court definitively says, and one of the higher courts definitively say that they absolutely have no rights to a tattoo at all. I hope you enjoyed this first installment of Friday Live on Facebook.